Care, Ruth Overton.
Good morning. A young mother of 5 is currently...
State your name for the record, please.
Oh, my name is Cynthia Orr, and I'm arguing on behalf of Hannah Overton. A young mother of 5 is serving a life sentence without the possibility of parole on discredited science, concealed favorable evidence, and misdirection has plagued this case from the outset. Brady claims that we've raised here and ineffective assistance of counsel are not mutually exclusive, Your Honors, in this case, where they occur together, where they coexist and are interwoven, a terrible injustice is done. Here, Miss Overton brought her 4-year-old child, Andy, to the Driscoll Urgent Care Clinic 3 miles from her home for treatment. They suctioned vomit from his mouth to clear an airway as she performed CPR on her own child, wondering why they could not respond to him more quickly and more competently at the urgent care clinic. He was rushed then to 2 other hospitals, Spawn Hospital and Driscoll Children's Hospital, different from the clinic where he started, where this journey began at about 5:17 p.m. It wasn't until 7:35 p.m. that the doctors, with all their medical knowledge, with lab test results and their training, were able to determine Andy had hypernatremia or sodium intoxication. His vomit collected at Driscoll Urgent Care was the only unadulterated fluid retained from Andy before medical personnel gave him sodium as part of their routine treatment, of course. Sodium products like an IV drip, epinephrine, sodium bicarbonate, and other measures. This child with hypernatremia underwent aggressive life-saving measures. CPRs, nasogastric tubes, breathing bags, and the like. Intraosseous lines into his bone marrow to deliver these sodium-containing medicines. This first unadulterated evidence was collected by an evidence technician from that Driscoll Urgent Care Clinic and stored away, but his report was never provided to any of the defense lawyers, not the civil.
And why do you say that's so important? What is so important about that?
Because that's where the misdirection began, Your Honor.
Okay.
Because this collected evidence was called something else. It was called gastric contents obtained from a hospital. Well, Spawn and Driscoll Children's Hospital didn't collect it. It was at this urgent care clinic, and it was the first vomit, the unadulterated evidence, because it showed, Your Honor, what this child ingested right before he showed these signs of illness, and it showed that what Hannah Overton told the doctors and the police and testified to at trial was the truth, that she'd given her child soup with some Zatarain sprinkled in it, and then some water with a very little Zatarain sprinkled in it because he wanted to continue to eat.
So are you saying that this vomit had a very small concentration of sodium?
Yes, ma'am, it did.
And the significance of that is what?
The significance of that is 2. 1, that the sodium that this child took in that was killing him had already migrated through his body, left his stomach.
Is your position?
It left his stomach, and so we know 2 things. He couldn't have been saved, and that he ingested it earlier on his own. That the state's theory that Hannah Overton forced a slurry of spices down his throat was not true. That's not what was in his stomach.
You said we know that, but the court found that, made several findings of fact that are contrary to what we say we know. And one is that court finds that the attorney for Ed Condit, one of the defense attorneys, testified that the bag containing the vomitus was made available to him. but he chose not to open it to inspect the contents. Is that
And that's where I
correct?
think, Your Honor, where I say that ineffective assistance of counsel and Brady intersect. One, Brad County went to view.
But the court also finds that the low 48 sodium test result actually mentioned in Overton's application for writ was clearly known to the defense at the time of trial, and the applicant failed to prove by preponderance that the evidence of the prosecutor or any agent of the state failed to disclose this evidence. to
That's
the
not
defense.
correct, Your Honor.
That's not finding fact?
That's not the correct finding of fact.
Okay.
It is true that a test result, 48, was revealed to the civil lawyers, the child custody case. It was identified as lavage, that is, irrigated stomach content in a hospital later on in treatment. Thus, not this unadulterated first vomit that tells us what really happened. So, and the lawyers who asked, where's this first vomit? We're told it doesn't exist. And every lawyer, Your Honor, the second chair prosecutor said, my first chair told me and all the defense lawyers the vomit didn't exist from the Driscoll urgent care and that this was lavage.
Now, the findings of fact are contrary to that, aren't they?
That's right.
Yes, okay.
Yes, ma'am.
And you
Yes,
filed
ma'am.
objections to finding fact?
Yes, ma'am. Yes, ma'am. I did, with record references, the clerk could click on to see where I'm correct about these issues in the electronic copy and in the hard copy with the actual transcript attached to the objections. What's more important, Your Honor, is when Brad Conant walked into, and he was the only lawyer, I asked all of them, that went to the physical evidence that represented Hannah. He went in, he looked at the bag, and it has not Driscoll Urgent Care's address on it, but the Overton's home address on Parkview Drive. And just like all the other condiments in the pantry of the Overtons was labeled, this bag containing the vomit said reddish-brown liquid. It said BEMIS, B-E-M-I-S container, which I didn't know was a medical receptacle. It might be a brand name, I'm not sure. And he had no interest in that. By this time, he'd taken the deposition of Dr. Fernandez, the medical examiner, who told the lawyer who took that depo, this is something collected in the hospital down the line. The lawyers had been told this was lavage. The lawyers had been told the vomit didn't exist anymore, and he's looking at a bag containing something from the Overton's home address. He's not interested in that. And the chain of custody documents at State's Exhibit 1 in the writ hearing has a notation, container not open, Brad Condit present. So, should he have opened the bag? Yes. That would be ineffective assistance of counsel, not to overturn and look at everything. Should the state advise, sorry, Your Honor.
You state as a fact that the state hid this evidence.
Yes.
The court finds that that is not so. Is that correct?
The trial court does, and that's an incorrect finding.
Okay. The reason I ask is because throughout your brief, there are statements that sound like they are statements of fact, and I can't tell if it's one of your witnesses testified to that, the court found it as finding of fact, this is your theory, or this is undisputed. And you state as a fact that the state hid Brady evidence, but that is not undisputed, and it's contrary to the findings.
I think there is undisputed to this extent. The second chair prosecutor and every defense lawyer said, we were told this doesn't exist. Well, it does exist, Your Honor.
And so that is your argument that the state hid evidence. But you stated as
I believe it's sustained by the facts presented at the writ hearing and at the trial. And I think that the only evidence...
That's what I mean. That's your theory. It's there.
The only argument to the contrary is the prosecutor who says, I don't recall.
And the judge found that to be true.
The judge found she didn't recall, but there was no evidence upon which he could base the finding.
Well, she also said that she would have turned over Brady evidence and found that was true. Is that not true? Correct?
She believes she would have, but she had no recollection of doing so.
Okay.
Yes, ma'am. All right.
Ms. Orr, on a slightly different topic. I believe it's your position, or your theory at trial was that this was a horrible accident, that it was Andy himself who had eaten the salt. Is that your theory at trial?
That is our theory.
Okay. The Supreme Court has said in Harrington v. Victor that there are some cases in which the defense absolutely requires expert witnesses and an expert investigation. And I'm wondering to what extent, if any, the failure to call Dr. Maurice and Dr. Cortez works into your ineffective assistance claim.
It is really the heart of it, the heart of the matter. Because here, both Dr. Fernandez, who in the written hearing said he would defer to Dr. Maurice, and Dr. Rhoda, who said he doesn't know about how much time is needed to get quick treatment for salt poisoning. He only knows about cardiac arrest out of the hospital. Dr. Maurice's testimony was crucial. He, in his deposition, and if he was called to testify live, as the lawyers said they planned, would be able to testify about how quickly sodium would be absorbed, and in this case, how it would have shut down all the organ processes. So what we have preserved in the stomach is what this child last ate, because the earlier high salt had migrated. Otherwise, his stomach sodium would have been at 1,600 or 2,000 milliliters per liter. That you would die at this level, even if this happened in the hospital. And that even with immediate care. And that these scratches and bruises and all this that were mistaken for abuse were caused by coagulopathy, which means this child couldn't clot. Any touch would cause this under skin bleeding, and any scratch he had would ooze blood.
Let me interrupt there for a moment. So there was testimony, I can't remember which doctor, I think it was Dr. Rhoda testified that there was not one continuous area of skin that did not have a mark, a scratch, or a bruise on it on this 4-year-old child.
Very clear indication of coagulopathy, Your Honor, because that's what happens.
Okay, so the scratches on the neck, the bruise on the nose, that was all because of the what you just
And
said?
life-saving measures, yes, Your Honor, and I can't say it well either.
Thank you.